Hello, everybody. Welcome. We're really excited that you could join us for today's L&J morning break. We hope you're enjoying these. Today's session is on what's probably on everybody's mind, opening association amenities. We have Rob Stein and Catherine Roberts here to talk today. A couple of quick things. First, thank you for all the awesome positive comments about these. We are not above being happy to hear that you are enjoying these and hear good things about them. So continue to send them. And as you have ideas for topics, feel free to send those to us as well. We're going to continue this platform. We think it's been really helpful. Short, high level, quick answers to some of the common questions. We have gotten some of your questions in advance and we've worked some of those into the program. We'll talk about them. If you'll notice on your side panel, there is a spot for you to actually send us questions. We won't answer them during this session, but our plan is to get back to people individually. So we'll reach out if you send questions, please do that, or send your hellos. We like that as well. So we are ready to start. Rob and Catherine are going to take it away. We miss you guys. Thank you and enjoy.
Thanks, Jay, and good morning, all. And I hope everyone and their families are feeling and doing well. The White House, Governor Kemp, and the CDC have provided written orders, policies, mandates, and guidelines as to COVID-19. And now they're adding a new layer with gating criteria and phase steps in the reopening of America, our state, and to a lesser degree, your amenities. Now, I'm not downplaying this. To the contrary, there's a great deal of helpful information, but to no one's surprise, not all the information is synchronized and there are missing pieces, there's ambiguities and confusion that's been created. What Catherine and I are going to try to do is cut through some of that this morning. First, let's keep in mind the big picture. The government plan for reopening businesses in other parts of society is not based on waiting for a vaccine for COVID-19, but rather to go on a step-by-step increase in activity with safeguards, with each step being earned theoretically through declines in the number of deaths, as well as declines in the quantity of folks with symptoms, coupled with increased testing and increased medical facility availability. That's the starting point. So our reading of this information is that while homeowner associations and condominium associations are nonprofit corporations, and nonprofits are covered by much of the governor's executive orders, we don't fit exactly into many of the executive order statements that have come out to the reopening, but we're going to go through that with you. What is clear is that the overall requirements of Governor Kemp's public health state of emergency do apply for things like social distancing, taking steps to mitigate the spread of the disease, sanitizing, and other steps that need to be taken. Perhaps most importantly, many of the requirements from Governor Kemp's executive orders will likely be seen as reasonable standards of care as we go down the road for our community associations, meaning if you want to lessen risk, if our boards want to lessen their risks, it's going to be important to follow the mandates that the governor has put out. What you're going to hear today is there's not a magic moment, not a clear line for when each element of the association's amenities can be either softly or fully reopened. The reality is that the plan for each community needs to be one that addresses the specific amenities for that community, the budget for that community, the population of that community, and the risk tolerance for the board and for the association. In the next few minutes, I'm going to discuss some specific amenities, make some recommendations. Then Catherine's going to go more deeply into risk considerations, risk analysis, and recommended steps to what we consider you need to do to reduce risk. So again, here's where we are. The governor's shelter-in-place order, the broad one, will end as of midnight tonight, except for seniors age 65 and over and those who are medically fragile. They continue to need to shelter in place through May the 13th. May the 13th is the next critical date on the calendar for the governor's executive order. All his executive orders as to shelter in place and for the public health state of emergency run through that date, but not beyond. So the first amenity we want to cover is gyms and fitness centers. Governor Kemp's most recent orders from the 20th and the 23rd don't have any specific limitations that they only apply to your typical for-profit, gyms like Lifetime and other big gyms. So until we have further guidance, we have to consider that the governor's requirements may apply to community associations in their gyms. We've had emails forwarded to us on the other end of this from homeowners saying that the governor's orders require the opening of gyms. Well, of course, that's not true. This is just an option for the opening of gyms. But if they are reopened, then the governor's included 16 actions. There's 16 actions that need to be taken in order for gyms to be reopened. And some of the most significant ones, particularly for associations considering reopening their gyms, are the requirement to screen patrons at the entrance. Patrons exhibiting a temperature greater than 100.4 degrees are not to be permitted to enter. What does this mean? Well, we think it means you've got to have a thermometer, a forehead thermometer, a thermometer with sheaths on it so that temperatures can somewhat safely be done. Requirements, some of the other significant requirements from the 16 items are limiting occupancy, providing wipes at or near each piece of equipment, requiring users to wipe down before and after they use the equipment, requiring a worker to patrol the areas to enforce the wipe down policy and to conduct additional cleanings, as well as cleanings of the bathrooms. This worker is also to enforce social distancing and to prohibit folks from congregating and to encourage people to leave when their time is up. Well, when they finish their workout. As we stated, it's not an absolute that these measures apply to community associations, but if we are looking forward to a standard of care that may be applied to us, it certainly may be these 16 items. And again, these items are in place only until May the 13th. May that be extended by the governor? Sure, but maybe it'll be extended and reduced. A lot of community associations we're talking to don't have the resources to meet these requirements. I've had a few board members say to me they're not going to open as a result. And for them, the cost is an issue, but it also provides them a convenient way to not worry about the liability side of this. Others have chosen they're doing a limited reopening, a soft reopening, a few people, limited hours, something that their expense budget can take care of. Keep in mind, again, these requirements only extend to May 13 at the moment. Let's go on to swimming pools. For pools, the governor's order required the closure of all public swimming pools until May the 13th. Now, association pools, we consider as being public pools, and we think the governor considers them to be as public pools because they're regulated as public pools by most of the counties. Through swimming pool ordinances and inspections. So we think you want to consider that closure should take place, if it's not already closed, between now and May the 13th. Now, that said, for many communities, Memorial Day weekend is the more typical time to open pools, and we'd recommend you continue forward, if you're not already, with seeking to get the pool ready to open with inspections and so forth. That's what we're telling our communities. And keep in mind, under the CDC guidelines, swimming pools are probably one of the safer things in actuality that folks can participate in. But chlorine is stated in the CDC guidelines. The chlorine kills COVID-19. So I think the real concern is not being in the pool effectively as much as it is, and probably what the governor is focused on, is all the activity along the sides of the pool, the challenge for social distancing, and the possible spread of the disease. So we may expect to see perhaps more guidelines from the governor come May the 13th that may give us some criteria. And I think we ought to be prepared for that anyway, just based on social distancing, moving the furniture aside, reservation systems, and other things, sanitizing things that are around the pool area, bathrooms and so forth, being prepared in some ways for the same things we're doing on gyms, seeing a similar set of requirements perhaps coming into place that is applied to pools. So let's move on to clubhouses. Again, no specific guidance from the governor on clubhouses and those types of facilities at this point, but we should take into account the things that are otherwise being required. Consider that if we allow people to use them, it's on a limited basis, social distancing, use of masks, patrolling, cleaning, and so forth, same ideas that we're seeing on other amenities. Finally, I'm going to touch on tennis courts. Again, no guidance from the governor on this one. We have seen some standards come out from the United States Tenants Association, the USTA. So not an official word, but with the USTA, they have been telling our folks not to use courts, but they've now integrated advice with the president's reopening of America. And they are saying that singles play, not on team play, but singles play with folks staying on one side of the court, with a set of balls only being used by each side of the court. There's some criteria on their site where some limited tennis play could reopen. Again, association's going to need to have that on a reservation system, on a cleaning basis, perhaps some patrolling that takes place to make sure that it's not turning into a congregation of people. So with that, I'm going to close and turn to Catherine, who's going to discuss some of the risk elements. Thanks.
Thanks, Rob. Glad you guys could join us this morning. I'm just going to jump right in, and I'm going to discuss the liability aspects and waivers, disclaimers, signage issues that we have here with COVID-19. So really one of the more concerning aspects of the COVID-19 pandemic, and what has triggered added concern for many communities, is that the community insurance policies that do provide general liability coverage for common areas, they are typically going to provide exclusions for viruses and communicable diseases like COVID-19. So this means that any claims relating to contracting the virus on common property will not likely be covered. So we're looking at a liability risk that's even greater, given that that is the case. So that's why, as Rob was saying, that these very measured and cautious approaches and opening the amenities are now so important. So with that in mind, when we do decide to reopen at some point and establish policies pertaining to use and operation, it's really important, based on what we know right now, that our members understand that opening of the pool and other amenities doesn't mean that we are warranting that these areas are safe to use. So, we are recommending that a communication to the membership, along with posting signs that include liability disclaimers and provide notice of the use limitations, all of that, and established policies for using the facilities will help in limiting an association's exposure to liability. As far as the content of these disclaimers, your attorneys can certainly help you. We can certainly help you draft the language for a disclaimer. But, from a general perspective, most of the disclaimers that we were looking at, we just want to make sure that, like I said, the users are aware that we're not warranting that these areas are safe, or that they otherwise won't be exposed to contracting COVID-19 while using these facilities. Also, we definitely want to make clear that any users are certainly responsible for their own health and safety, and they should follow CDC guidelines and current governmental practices that have been either required or recommended. We certainly need to include, to an extent, that we are also meeting our obligations in utilizing some of these cleaning and sanitation measures that are enhanced for us at this point, but also, that all residents and all users are basically responsible for themselves. We can include language that says, everyone agrees to comply with all of the use policies and regulations, and that, the users agree to hold us harmless and things like that. But it's really important to recognize that even when we do issue these disclaimers, disclaimers alone are not going to, in our opinion, really do much for an association from a liability perspective. And what I mean by that is that, simply just issuing a disclaimer, for instance, use the pool at your own risk. COVID-19 could be present. That alone, without these additional sanitation and cleaning measures and the social distancing monitoring and all of that, that's just, it's not going to, we can't just use a release to basically release us of our general obligations, as Rob was discussing before. So we just want to make sure that it's clear that yes, disclaimers certainly help in supplementing those measures and all working together to help limit our liability, but the disclaimers alone are not going to cut it. So moving on, as far as waivers are concerned, we have gotten quite a few questions from our clients, can we require our owners to sign a waiver to use the facilities? And the waiver would include certain disclaimer language like I was discussing, but basically requiring that the owners sign off that they're agreeing to release us of liability. And as far as waivers are concerned, I think that in the limited circumstances where we are providing for a limited opening of the amenities, more so as an accommodation before some of these additional requirements are lifted, like the social distancing and things like that, then it's probably reasonable to require these individuals to sign a waiver in those instances. But when we do eventually open it up to all of the residents and users to use the amenities, it's not exactly clear that we can require that that they sign a waiver at that point. But again, it doesn't hurt to, in the limited circumstances, put it out there. As far as signs are concerned, we know that according to Governor Kemp's April 23rd order, that there are certain requirements, especially pertaining to the gym and fitness centers, that signs be posted around the facilities that basically provide, that the hand cleaning and the safety measures that the CDC has recommended, and also indicate that anyone who has contracted COVID-19 or come in contact with anyone with the virus is not permitted to use the facility. So CDC has some great resources. They have some already basically pre-made signs in PDF format that you can just print off and utilize in posting those in and around the facilities when you do open them. Finally, on this topic, there was, and we did get a question beforehand, but as some of you may know, there have been some discussions about some potential legislation that Congress may be considering that would effectively limit liability for businesses. Right now, as far as we know, nothing has been actually proposed. We haven't seen a law that's been put out there, a bill has been proposed. But, at this point, I think that doesn't, the prospect of having something like that on the table, whether it may or may not help, that's to be seen. But I think regardless, in any type of law like that's imposed, to the extent that there's even authority for that, it's likely going to require that businesses meet a certain minimum standard anyway for certain health safety practices. And it's probably going to be the same as what we're looking at now, such as those that are in Governor Kemp's order and what the CDC is saying. So, at the end of the day, those are not going to basically, like with the disclaimers, help us in just totally relinquishing our responsibility to otherwise comply with these additional measures. Unfortunately, I know that, we've touched on that it can be a significant drain on resources, but, at this time, we are thinking that all of these additional measures are still going to be required in order to open the facilities. So moving on, I do want to touch on briefly senior communities, because as you probably know, the CDC and other health agencies and governing bodies have basically found that older adults and people of any age who have serious underlying medical conditions might be at a higher risk for severe illness from COVID-19. And I think CDC has even issued a statement that based on what they have found, 8 out of 10 deaths reported in the US have been adults 65 years of age or older. So, with that in mind, I know that Governor Kemp's April 23rd order has basically, and like Rob said, that this specific demographic is required to continue to shelter in place. So when you have these older communities, there's just this, you have an additional consideration that you have this higher risk pool of residents that you have to consider. So probably you are looking at, with these older communities, the liability risks, they may be greater. So that's why it's very important to consider who you have living there, and the guidance that the CDC and that our local governments and state have put out as to older adults. I think we know that the CDC and in Governor Kemp's order, as part of the shelter in place, visitors are limited for that demographic, and it's recommended that they limit activities. So, with that in mind, there could be additional measures that we would take in an older community like that that we might not otherwise take in a younger, single family community with kids where the risk is not as high. For example, you might consider prohibiting all guests in a community like that. And I know for some 55 plus communities that are in compliance with the Housing of Older Persons Act, there are certain basically exemptions for discrimination claims based on familial status. So you could institute in those communities some rules where you are basically setting aside certain times that certain age groups can use the facilities. So if you're concerned about, the younger residents possibly being a risk of exposure for the older residents, you could set aside a time for the 18 years of age and under to use the facilities at a certain time so that, you can keep them separated and it's less of a risk for you. And then, really, the government hasn't said that these senior communities have to close, and we haven't seen that in the CDC guidelines. But I think that it's also important to keep in mind that Georgia really is at the forefront of the reopening process. So much is still to be learned about how to reopen these areas in a safe manner. And with that in mind, it's really opening of these facilities at a minimum, providing only very limited and controlled use is probably going to be a best practice. Ultimately, boards just need to stay informed as to what the CDC, the state, local, federal agencies are saying and recommending, because really much remains to be known about this virus. So with that, I think that wraps up our discussion.
Awesome. Thanks, Rob and Catherine. Great job. So my takeaway, I think you guys know I'm pretty practical with stuff like this, and I certainly lean towards keeping people safe. Everything Rob and Catherine have said, and we've said in all the others, is that if there is a message in what's going on now, it's that the standards of what we've got to do are certainly increased, clearly. And that, for me, makes this whole situation a plaintiff attorney's dream. That we should certainly expect that people are going to be out there looking at whether they can make claims on either side of the issue. Opening too early, not doing enough. And regardless of whether Congress adopts legislation to try to protect us or the president adopts an executive order, if that's even legal, to try to make nobody in America liable for COVID issues, we continue to have a covenant that requires us to maintain and operate our common areas. And the courts have said consistently that means maintain it safely, operate it safely. And that standard changes, and it's clearly higher right now what that standard is. So just the disclaimers of we're not liable, we're not responsible, we're not going to do anything we believe are just going to be ineffective. So the answer is do the right things and be cautious, be safe, be conservative about your openings, and follow the guidelines. On our website, we've got blogs that talk more about the specific guidelines, links to them so you can get them. So come visit our blogs. Our YouTube channel has our earlier videos on these issues. So please feel free to watch those. We'll post more as we go. Share those with your boards. And definitely stay safe. We miss you guys. We hope to see you soon. Thanks for joining us. Take care.